That's not our job.
Absolutely.
Right.
Our job is as a trier of fact. We are going to focus on one controversy, and we are going to focus on the set of facts, and we're going to make a determination for this case.
Yeah. Welcome back, guys, to Cases and Cocktails. This is episode 17, and we're here today again with my beautiful wife, Janice. How are you doing today?
Good. How are you?
I'm doing fantastic. We're pretty lucky today. We got a special guest.
Yes, we do.
We have Ashish Joshi with us today, and we are super excited to have him here today because we're going to start talking about parental alienation. In April, which is coming up here next month, is Parental Alienation Awareness Month. And we want to kick off sort of this month of parental alienation and sort of leading into it with some talks about you. You actually have come down from Michigan, right, to do this?
Ann Arbor, Michigan.
There you go. I greatly appreciate it. And by the way, too, guys, just so you know, this is the second time that Ashish has come down to Texas to be a part of this. The first time, it wasn't on the podcast. It was actually at a CLE that we did last year.
Yes, we did.
I really appreciate that. That was a really great CLE that we got to put together for people. So I greatly appreciate you coming and doing that, as we said. But more importantly, thanks for coming back down.
Thank you. Pleasure to be here.
I'll be honest with you too. Every time you come, we get in these great conversations about litigating parental alienation and doing these things. So I enjoy it, and I want everyone to know sort of what your background is and how you kind of got to be in this space.
Well, I'm a lawyer by training. As a lawyer, I focus on cases involving family violence.
Okay.
High conflict custody cases is a part of that. I also do a lot of teaching for judges, for attorneys, CLE programs, and guardian ad litems. But my focus is a case involving child psychological maltreatment allegations, which could include parental alienation. It includes domestic violence, but what we can largely put under the umbrella of family violence.
Yeah.
What made you decide to tailor or narrow your focus to those topics?
I don't think I ever made a conscious decision to focus on those just areas. It just the work started coming in, particularly in those areas as I started to do more cases. One case leads to another. And part of my practice, what I consider to be unique, is I litigate all around the country. Mm-hmm. So I'm licensed to practice law in Michigan, New York, and DC, but I have tried cases all around the country and internationally as part of the legal team. Mm-hmm. So I would go in to focus on certain issues. It could be cross-examining a child custody evaluator. It could be to cross-examine a particular expert, or to litigate an issue, let's say intimate partner violence or alienation. So that has given me somewhat of a broader look in how different courts around the country look at this phenomenon called family violence.
And you've given trainings, you said earlier, to judges and,
yes.
and to lawyers. How awesome is that to be able to be the one stand in front of them and teach them about all this?
It's wonderful.
Yeah.
It's wonderful to be teaching, and it's a lot of give and take. And frankly, every time I do that, I learn a lot more than I'm able to teach. But the questions are really hard-hitting at times, especially from judges who are from rural counties, who may not have as much resources as a larger metropolitan area, for example. And when you have litigants who are pro se, who don't have attorneys representing them, and they can't... they barely have money to find an attorney for themselves. You don't have a guardian ad litem, you don't have minors counsel, you don't have a custody evaluator, you don't have these experts. You have to still make findings of fact as a judge.
Mm-hmm. Yeah.
And those cases are really tough.
I couldn't even imagine trying to sort through or sift through all the pieces, right, in those types of cases and what judges have to go through. What can I ask just real fast? I'm going to put you on the spot. When they ask you those questions, what is your answer? You have to do it. Good luck.
I mean, in a lighter vein, that's your job.
Yeah.
As our job as attorneys is to try to prove a case. But there have been some really good cases coming out in some jurisdictions. For example, in Ontario, Canada, there was a good opinion from the appellate court which essentially said that we are taking judicial notice of the phenomenon of parental alienation.
Right.
That you don't have to go and reinvent a wheel in every single case, whether this theory is true, whether it exists or not.
Right.
It does exist, and where there are facts supporting that theory, it's very damaging to the kids.
Right.
And as a trial judge, you don't need an expert to come to your court and tell you that there does exist the dynamic of alienation in this case. You can make those findings as a trial judge, and you should.
Right.
So that has simplified a lot of issues in Ontario courts on that area. But sometimes judges still believe that they need a psychologist or a psychiatrist to come in and tell them that this is a case involving parental alienation or abuse, and here's what you should be doing, judge. It gives them some comfort level,
Right.
especially if they're going to order a mental health intervention,
Right.
because these are clinical issues as well.
Right.
What kind of advice would you give to someone that doesn't have the financial resources to have experts or paraprofessionals on the case that is making an allegation of parental alienation and has to prove that to the judge?
Okay. So if I can take a step back,
Sure.
because we need to go into certain background to answer that question.
Okay.
You just got to stay in frame. I think that's the only thing you have to do. I think. Is that right? That's right. Okay.
Yeah.
That's all he says. All right.
I think one of the problems that has come across in litigating cases involving parental alienation is that the term parental alienation is in the overkill zone.
Yeah.
You know, it's a
It's a buzzword, man.
It's
It's
a
a thing,
buzzword.
right? Throw it out there.
You
Yeah.
hear about it, you read on it on social media. There are video clips and YouTube videos and whatnot. And people just use that in litigation without understanding it properly and without actually appreciating the implications of it and how it's going to turn out in litigation. I think what's more helpful is to focus on behaviors.
Yeah.
If you have a certain set of behavior, if you have a certain set of pattern of behavior, let's say one parent is repeatedly interfering with the other parent's parenting time, is repeatedly bad-mouthing the other parent in front of the children, is repeatedly doing something that is just inappropriate by even common decency and common sense, sharing inappropriate information with the children. Focus on that.
Okay.
You don't need a label.
Right.
You don't need to call it parental alienation. And there are plenty of decisions from the U.S. courts all around the country which have focused on those behaviors and talked about various things without using the term parental alienation.
Right.
I think there's a huge issue with lawyers and mental health experts as well sometimes when they zero in with a mindset of a zero-sum war game.
Right.
Or a binary solution.
Binary. That's what I was going to say. We talked about that
Right.
previously. Yeah.
Either it's parental alienation or it's domestic violence.
Yeah.
Either, let's say, mom or dad is alienating, or the other parent is abusive and deserves to be rejected.
Yep.
It's a wide spectrum. There
Right.
could be a lot of issues in between. Doesn't need to be either or.
Right. It's just like anything else in litigation. It doesn't have to be black and white, right?
Right.
Most of the time, there's a little bit of gray, right, in the totality of everything that's there. You said that lawyers and professionals and even I think courts, we want an answer, we want a diagnosis, we want a label, we want to say this is what's going on here. Oh, that wraps it all up, and as the human mind kind of constructs sort of this abstract around it, we say, okay, we can rationalize and we can understand why this happened because we were able to put this label on it. And I agree with you. I know that for me, I've gone to court and intentionally not said the word parental alienation, right? Because I didn't want to use words like psychological maltreatment or, these behaviors are affecting the parent-child relationship, right? And that's important because I think if you can get to the same space without throwing that label out there, that buzzword, then I think the court's a little bit more receptive to it, at least in my experience. Do you agree?
I agree. Why do you think that courts are so adverse to accepting that parental alienation even exists?
I don't think they are that antagonistic to the term parental alienation. Now, you will find decisions that have come from the courts disagreeing with the allegation of parental alienation in a particular case. For example, judges have wrestled with allegations of alienation and have come back and said, no, I don't think this case involves alienation because of the following reasons. But in the past 10 years or so, the courts have shied away from trying to determine whether parental alienation is a scientific theory, whether parental alienation syndrome is in DSM-5 or 4 or not, whether Richard Gardner, who came up with parental alienation syndrome, really knew what he was talking about. I mean, they're basically shying away from that and say, that's not our job.
Absolutely.
Our job is as a trier of fact. We are going to focus on one controversy, and we are going to focus on the set of facts, and we're going to make a determination for this case. And that's what you see. And that's why I think one of the really helpful things to happen in the past 5 years is the joint statement that came out between the AFCC and the National Council for Family and Juvenile Court Judges, NCJ-FCJ, which focused on what should the trial courts focus on when determining child custody disputes. And out of all the other different factors that they enumerated, one factor was parental alienating behaviors. They didn't use the term PAS. They didn't use the term PA. They focused on the behaviors. And folks agree. I mean, you will never find an expert or a judge or anyone who is going to say that there is no such thing as alienating behavior. Because behaviors do exist.
Exactly.
The only controversy and the conflict in litigation is whether that's justifiable behavior, whether that behavior is engaged in by a parent to protect the child from an abusive parent.
From abuse,
Or it's not, and it's bad behavior simply. Put it that way.
It's a lot about the behaviors, and we talk about this a lot of times when we're talking about litigating these cases. I get to ask these questions because you literally wrote the book about it, right? You wrote the book, Litigating Parental Alienation, right? That's your entire thing set out, and you did it with the ABA, correct?
Yes. The family law section of the ABA.
Of the ABA. Fantastic book, by the way.
Thank you.
And I want to talk a little bit about, when you have these behaviors, they exist, they're going on, but it's about how you present it to the court. It's about the presentation that you are going in to do. As lawyers, I've always said this, you say, or I say that you got to collect the data, you have to organize it, and then you have to present it, right? How do you approach it? Do you approach it the same way?
I do.
Yeah.
I mean, some of the times the mistakes that some lawyers make is to not go to the court early on. There's this fallacy that, let's avoid the litigation. Let's keep the children away from the conflict. And that's all good and well-meaning in its place. But if you do have those behaviors, then the sooner you go to court to address that, the better off the family will be. The sooner you get the intervention, right intervention, the better off the family will be. And it doesn't have to be what the media or the social media claims it to be. Not every case of alienation requires a reunification, quote unquote, camp, or some no contact order, taking the kid away. That's absolute nonsense. In most situations, what you need is a family systems approach where you're working on the family dynamics with the entire family, not just one parent or the kid, and trying to take the kid away from a parent. But early intervention is what makes it less toxic. What makes it far more cumbersome and difficult is lawyers file motions, they argue parental alienation, but they don't go through an actual trial or an evidentiary hearing. There are allegations made from both sides, and they come and they put together some solution
an agreement
to avoid litigation.
An agreement,
And it goes downhill. Because those behaviors go unchecked.
And it's, what in my experience in doing this, most of the time, I won't say all because the definitive statements are typically not true, but most of the time when they come in, that's exactly what's happened by the time they get to me, right? There was behaviors. Most of the time there was litigation. Then someone got really scared on one side of that litigation and they ran to mediation or an informal settlement, got an agreement, and they said, okay, here we go. We're going to move forward from now, right?
Right.
And the problem is, at least in this great state, not all states, but in this great state, the law, the family code says you can't go back, right? So from that line in the sand moving forward, right, when those behaviors start again, you can't go back and talk about the behaviors that got you here. You have to start from that order forward, and so it's very limiting, right? And there is a way to go back, but it requires proving that it's happening on this side. And it's very difficult because what happens then is you get back in litigation and then they're like, well, let's just get an agreement again. Or you're like, wait a minute, we just did this, right? And it didn't work. We're here again. It's still happening. And, Ashish, that's the biggest thing. I'm glad you said it. Talk about having an agreement or putting a solution in place. Oftentimes it doesn't help in these situations. That makes sense?
It makes sense. And if I may.
Yeah, of course.
What makes it worse in some cases is ex parte suspension of parenting time of one parent.
Yes.
Based upon allegations. You have a letter written by the child's therapist without ever talking to one parent who is being accused of horrible things. It's attached to a motion, and on Friday afternoon, the judge suspends the time ex parte with a goal in mind, perhaps, that you're going to get an evidentiary hearing soon, and that soon doesn't come soon enough. And months go by without the kid seeing the other parent. And then you have a new normal and a new status quo. And what is problematic in these cases is that one parent is held to an impossibly idealized standard.
Yes.
What is a perfectly okay parenting style, disciplinarian or authoritarian or even authoritative, I said it the other way, authoritative or even authoritarian, let's say. Even if a parent happens to demonstrate authoritarian parenting style, that doesn't mean that the parent is abusive.
Right, 100%. Right.
That means that the parents perhaps need coaching.
Right.
He or she is teachable. We can work on family systems therapy. We can work on joint counseling, a lot of things. But to cut the parenting time away deprives that parent and the child of working things out,
Right.
Because every relationship has tension. There's conflict. But when you have something as decisive as suspension of parenting time without evidentiary proofs and findings, that just sets the whole case in a very negative light.
And the optics on it are what they are then. I mean, even though the judge recognizes that we did this to be cautious or to protect the child until we can get into court, even then everyone in the courtroom feels a certain way about the person that wasn't able to see the child.
Right. And protecting the child is also, a big umbrella right there. There's a difference between a feeling of being uncomfortable or even some anxiety versus trauma.
Right.
The word trauma is just misused and overly used in these cases. Now, let's say there's a furor or a brouhaha between the parent and a child.
Right.
There happens some incident, the dad or mom engage in some disciplinary action, the kid says, I never want to see you again, and then months go by without any contact. It just sits there and festers.
Right.
And you have the new reality, you have new narratives coming out. The kid's working in therapy without the involvement of a parent.
Right. Working on therapy to continue to perpetuate what they're currently doing.
Right.
There's no going back. I didn't mean to cut you off, but yeah, I mean, it's
exactly.
you're putting the kid in a situation where, hey, I'm going to go work on your mental health, and by the way, we're going to do it while this other parent's gone, so that becomes the new normal.
Exactly.
Right.
That's a problem.
I want to say this too, and we got some other topics to get to, but since you kind of brought it up, and Jay, you kind of touched on it too. There's two things. One, when you take and you say this parent, out of caution or precaution, and yes, I'm going to talk about that in a minute, but when you take their time and their access away from the child, this creates a power dynamic that parent is now placed at the bottom. And the child is elevated above that parent. The other parent is elevated above that parent. And at this point in time, it's no longer a space where you can effectively exist. This is my opinion, and people get mad at me, and that's fine. You can't exist in a co-parenting relationship that way. You just can't. And the reason I say that is because you can have one parent have more power than another parent. That happens all the time, and literally that's what we go in court and fight about primarily, right, is who's going to be the primary parent, right? So it's literally what we do. But when you elevate that child above the other parent, that's not a co-parenting relationship anymore. The child now is validated or is being the child's behavior is condoned, right? This, I don't want to go see mom or dad, or I don't want to do this, or I want. Look, man, I mean, if you've got kids or you've been around kids long enough, if you just let them do what they want, they'll rule the world, right? I mean, that's what they'll do. And it's amazing to me that we do that. And then we look at the parent and we say, hey, I need you to prove, one, that all that bad stuff that we alleged didn't happen. And so if it never happened, proving a negative is, a little difficult. But
I want you to prove that you are safe.
Right. Well, I want you to prove that you never abused the child. I want you to prove that you never neglected the child. I want you to prove that you were never mean to little Johnny or little Susie, or you didn't do this or that. And it's like, I didn't. You got to prove it, though. You can't just say that. You got to prove it. And then on top of that, I want you to work on your relationship with your child. By the way, you can't talk to them. You can't
Unless
see
you're
them.
in therapy.
Right, you can't see them, and you can only see them when you come to therapy. And by the way, the other parent's going to bring them.
Right.
Just if you just say the words out loud, and by the way, this is how it happens often in my experience, because the courts act out of caution or precaution. And I'm not saying you shouldn't act out of caution or precaution to protect children. We do this all the time. I've filed hundreds, thousands of TROs or protective orders to go protect a child based on things. We literally did this week, right? So I get that.
But there's a difference.
But there's a difference. And
there's a difference between giving the child a voice and giving the child a choice.
Exactly.
Children should definitely have a voice, but children should not be making a choice whether to see a parent.
And why do you
How
believe that?
often to see a parent. Yeah. That's a decision that the court needs to make in the best interest of the child. And what you are describing is a very unhealthy dynamic where children are over-empowered.
Yeah.
And the parents are disempowered. So the parent gets demoted to the level of being a child,
right.
losing all agency, all parenting,
all autonomy,
nothing. And the child gets to dictate when or how he or she's going to see the parent. Yeah. And in some really absurd cases, the kids have 911, CPS, GL on their phone.
Right.
And if a parent tells them to go and clean your room, you can't talk to me like that. I'm going to call my lawyer. Right. Right. You see the situations carry on.
And the idea that you're going to make that better somehow with that dynamic existing is very difficult, in my opinion. My opinion. I want to transition a little bit, and I appreciate that. I want to transition a little bit, though, into a little bit of parental alienation and how we present these things, right, to the court, and how certain things play into sort of like family violence that you talked about earlier. And it's the same stuff we're talking about here, right? We talked about, or you kind of mentioned, you need to go litigate this. You need to get this in front of the court. And that is very counterintuitive, I think, to some of our colleagues. I'll put it that way nicely. And so, it's a space where you say, okay, hey, you need to go do this. Talk a little bit about what your concept is of how to present that. I know it's a big task. You're not going to be able to get into all those details, but how do you approach that, and what's that presentation? What are the things that you would want to see in a presentation?
It depends on the facts of the case, of course. But you don't need to walk into the court with a flamethrower. Right. You don't need to file a motion for immediate change of custody, no contact with other parent, parental alienation, all of that.
Right.
If there are significant problems that need to be addressed, you can, for example, ask the court for family systems approach in terms of in mental health intervention, or an assessment.
Right.
Depending on the jurisdiction, for example, some jurisdictions have what they call brief focus assessment.
Okay.
If a child is demonstrating what experts call resist refuse dynamics, resisting a parent, rejecting a parent, refusing to go on parenting time, let's get to the bottom of it.
Right.
Is the child rejecting a parent because the parent's inappropriate or deficient parenting style? Or is the child rejecting the parent because of some other issues, because the child is now of a different age group, cognitive, mentally, emotionally, whether there has been some dramatic change in the family situation, there's a death in the family, for example, did they move recently, what's going on?
Right.
Is the other parent influencing the child's decision?
Right.
If so, to what extent? The problem, Bryan, I think is lawyers and litigation looks for definite results. We look for certainty.
Right.
We know exactly what we are arguing,
right.
what it's
And
all
what we
about,
want.
and this is what we're going to prove.
Right. Yeah.
And social sciences, there's a lot of uncertainty because it's human behavior.
Right.
It's complex.
Right.
It changes. And that's where the rush to find quick and easy solutions can often do a lot of damage. That's why you have to be patient. But I think the single most important thing is that as you're working those issues out, you need to make sure that there's contact
Right.
between the child and the parent that's
parent.
being rejected.
Yeah.
Unless there are findings of abuse, unless you have a CPS finding that the parent is engaged in abusive behavior,
Right.
or there's medical report that the
Right.
child was physically harmed, then of course we have to
Protect the
protect
kid.
the
Yeah.
kid.
Have to.
basically put all the stops in. But failing those things, you have to make sure that there's contact, that one parent is not completely cut out
Right.
and basically asked to prove that he or she is safe or not dangerous. That's a reversal of burden of proof then.
Exactly. That's the hard thing, right? It's the hard thing of when you're on the side of the parent who's being alienated or rejected.
Right.
Your presentation has to be, and oftentimes those parents, by the way, are accused of family violence.
Yep.
Right. So it's an abuse allegation, whether it's physical, whether it's sexual abuse, whether it's even emotional abuse, right? Mean to little Johnny or little Susie, and little Johnny or Susie is having some sort of trauma because of that, to use that word. It's a space when you're trying to put together a presentation on that, right? And you've got to go in and you've got to try to come up with solutions, right? You're being accused of abusing your son or daughter, and I want primary custody, right? And she's alienating. You're right. You can't come in with a flamethrower. Talk to me a little bit about how you address that with the parent that's being rejected or alienated, and what that presentation involves for that person.
You try to educate your client, assuming that you have a client who is complaining of being rejected as a parent. Right. And you talk about different interventions that are possible and feasible. Mm-hmm. And you also try to educate them about what parental alienation is and is not.
Right.
How it's a wide spectrum. It could be mild alienation, moderate, severe, or no alienation at all.
Right.
You are talking about behaviors.
Right.
And let's take reasonable baby steps to get to the bottom of the case. But it's important to get some good findings made early on. Mm-hmm. Mm-hmm. Because if it's truly a case of deficient parenting or abusive parenting, then you need to have a sit down with your client and talk about it.
Right.
You need to talk about how certain parenting style is not appropriate, and you get a good parenting coach for your client. You make sure the client understands that. And what may have been a good parenting style when the kid was 6 years old doesn't really mean when the kid's like 14, So, I mean, it's sometimes common sense, but when people are caught in high conflict separation and divorce, and they are emotionally attached to those labels, bipolar, narcissist, alienator, abuser, then they just lose the sight of forest for the trees. Their big picture is lost.
Right.
And that's why you need to focus on the basics and bring them down. Right. And instead of going and just trying to argue a theory into court.
We talk all the time about, here at our firm, what we try to do is we talk about making our clients the best parent and the best co-parent they can be, so they can be the best litigant, right? And that's all it is. And I'm not talking about like, hey, this is how you read books to your kid or anything like that. I'm just talking about give you the resources, a parenting coach or whatever it is to help you, and then make you the best co-parent that you can be, which is different than being a parent, right? So it's how you interact with the other parent. And if you're doing those two things, then it makes our job as litigators a lot easier, doesn't it?
Exactly.
Yeah. And the other thing, and you use this word in a conversation that we had, and part of it is trying to make our clients likable, right? They're being accused of abuse. They're being accused of some really heinous things, and you've got to work on those things right there. Like you said, setting expectations and helping them be the best they can be. But you got to create some likability, right?
Right.
Especially when there's allegations of family violence.
Yeah.
So what are some ways that you do that?
Getting a good coach.
Yeah.
Okay.
I think having a good parenting coach or someone who can work with the client, someone who can be in that position of hand-holding, trying to help the client manage the anxieties of navigating through litigation, working on parenting style, working on presentation, having them understand what's it going to be like for the next 6 months until you get through a trial is a huge thing.
Right.
And some lawyers like to do it themselves. That's great. I personally don't.
Yeah, me either.
I'm not one of those guys who say I'm available 24/7. Call me. No, I'm not.
Right. That's exactly right.
You need boundaries. And sometimes when lawyers become therapists, when lawyers try to become parenting coaches, it doesn't end well.
No.
Right.
No, we're good. We're good at litigation.
Right. And there's also an issue about, burnout, secondhand trauma, getting desensitized to cases involving abuse and violence.
Right.
So you have to make sure that you provide some tools to the client.
Right.
You give them some choices and options because it dramatically lessens their anxiety. They have a game plan. They know what to expect. They know how it's going to play out in the next 4 to 6 months.
Right.
And if they are engaged in, let's say, some contact with the kid through our family visit or some of the text messaging or some whatever, they need someone to help them navigate that. It's very troublesome and very painful to receive a horrible text from your teenager.
Right.
When you get a text calling you names and calling you horrible, demeaning, derogatory terms, their impulse is to lash out.
Right. Or one, it's to defend.
Yeah,
right.
be defensive.
And the defensive thing is a problem, right? Because then it's just you're defending some allegations that are irrational and they're illogical. And there's no way that you're going to work through that. But then two, you escalate, as you said, and it becomes anger, frustration, that sort of stuff. And they're going to use all that against that parent.
And what's worse is lashing out on social media.
Oh, yeah. Oh, yeah.
Here's what I got from my kid, or that lawyer's a nasty piece of so-and-so, the judge doesn't get it.
Right.
And all that things put in social media on various family law groups and parenting groups, that's going to be fodder for cross-examination.
100%. It's Exhibit 1, 2, and 3, right?
Yeah.
That's
and it's no doubt it's painful.
Right.
It's horrible to go through that. And that's where a good coach can really make a difference.
Have you ever had a concern or even had a parenting coach subpoenaed as a witness by the other side?
Yes.
And how has that played out for you?
Generally well.
Okay.
Because if you do your diligence and you engage a good coach, he or she knows what they're doing.
Right.
So they can actually be very helpful to the court in trying to help the court understand how difficult it is to be in the shoes of a rejected parent. And the tools that they utilize to help the parent in dealing with communications, understanding how it's going to turn out to be. And in ideal situation, parenting coaches should also have access to the court-appointed family therapist.
Right.
So that everyone's pushing in the right direction.
Right.
What you don't want is the family therapist, the court-appointed therapist pushing in one direction, the child's individual therapist pushing in the opposite direction, the mom's therapist pushing in west, dad's therapist pushing east, and the lawyers don't know where they're going.
We're standing in the middle going, I have no idea what's going on.
Right. So it's helpful that there's flow of information, even though some confidences should be maintained within therapeutic relationship.
Sure.
But at least the effort is being made in the right direction.
Well, that way the team has the same goal.
Yeah,
that makes
the
sense.
team has a single, and you can navigate those confidences, right? It doesn't mean that I'm going to get all of mom's notes, right, from therapy, and they're going to get all of dad's notes from therapy, and we're going to read all the kids' notes, and we're all going to sit down and talk about it. The professionals can go and release the amount of information that they need to effectuate to push them together. It literally is the word family systems.
Right.
I mean, that's the whole idea behind it. You know what I mean? Like,
Absolutely.
to work together. I gotta ask a couple questions, and I told you this before we started. I could do this all day. I could talk about presentation. I could do this all day simply because to me it's very interesting, but more importantly, it's literally sort of the essence of what we do, right? And I'm glad that you touched on the coaching part, because it's something that we do here. We do it a little bit differently to preserve some confidences and that sort of stuff. But do you have parenting coaches that you use across the nation, or that you recommend across the nation? I'm not asking you to throw names out. My thought process is jurisdictionally, right? If I have a parenting coach in Oregon, it could help someone in Florida, though, right? I mean, it's still parenting.
Absolutely.
Parenting doesn't, whether you're in a different state, it doesn't change the parenting of or the way that you parent.
Right. I mean, this is not an area where you need a license, for
Right.
example, a therapy license to practice therapy, because it's not therapy, it's
Right.
coaching. So you could use a coach in California for a case in New York, because most of the coaching is done remotely
Right.
in any case. And since COVID, that has taken off.
Taken off.
You know? So depending on the situation, I mean, some coaches are better with men. Other coaches are better with women.
Yep.
Some coaches are really good at children who are adolescents. Other coaches have really good things to contribute when the kids are younger. They have all their weaknesses and strengths. So depending on who's involved, I would make that call.
Yeah, I can see a space where it would be helpful to have different dynamics. The interpersonal dynamics for the coach and the client is going to be huge. And making sure you got the right fit, and then that coach also fits with the litigation team, I think is the biggest thing. I got to ask this question just because it's been on my mind. You talked earlier about your work kind of across the nation, across multiple countries, across the globe. I'm going to ask you a very direct question. You ready? You ready? You're scared? Don't be scared. Don't be scared.
Don't be shy. Ask.
What value do you add to someone else's litigation team?
That's a great question. So I primarily work in two capacities.
Okay.
Either I come in as a litigation consultant, where I'm helping the lawyer craft a litigation strategy. For example, if it's a case involving family violence, what sort of family violence are we talking about? Is it domestic violence, intimate partner violence, child psychological maltreatment, alienation, what's going on?
Right.
And it doesn't have to just be one clear label. It could be a combination of a lot of factors.
Right.
But then help the lawyer pick the right kind of expert, whether we should be moving for court-ordered evaluation, or whether the kid's already 15 and we don't have time for that.
For that, yeah.
And we need to be going to litigation right away. Have to prepare for a good deposition of if there's been an evaluation. Let's make sure we take good depositions that can be used in litigation.
Right.
So that's the role that I play behind the scenes working with the lawyers. In other cases, I come in as co-counsel,
Okay.
where there's a practice, as you know, pro hac vice.
Yep.
So if I'm licensed in Michigan, New York, and DC, but I have a case in Texas, you being the local lead lawyer would file for my admission into the case. And in those cases, I come in to focus on clinical issues,
Okay.
forensic issues.
Yep.
Typically cross-examining the custody evaluator or cross-examining some expert
Right.
who is going to come to court and opine about certain things.
Right.
I don't handle the whole case. I don't handle the financial part, but just for parts related to high conflict child psychological maltreatment or family violence.
How often do you do that? Both of those? How
All
often?
the time.
All the time.
That's
fantastic.
that's my practice.
That's fantastic.
And that happens in international cases as well, where I'm part of the legal team. So I would have a case, for example, let's say before European Court of Human Rights, where I can't go and make an argument before the court because I'm not licensed there.
Right.
But I'm part of the team, so I can help the European attorneys and lawyers understand what are the forensic issues in alienation or violence that we are dealing with.
And you help them navigate that.
Yeah.
Right.
What are the good experts? What's the current research in the field?
Right.
And how do you present that argument before that trial of fact? Because that's the key. Who's your audience?
Yeah.
Right.
It's not like you have this one can argument that's going to work in New York, Florida, Texas, everywhere.
If it was, we just sell that, right?
Exactly.
Right.
You have to know your audience.
Yeah.
And, for example, one jurisdiction that has really come out with really great decisions, well thought out, well written, is Nebraska.
Really? Really?
If you read Nebraska's decisions for the past 10 years, they are really well written.
Wow.
Why do you think that is?
I don't know.
Okay.
I don't know, but
it's interesting.
They are well written, but they focus on behavior modification. They focus on the remedies that work, family system approach, sometimes changing custody as well. But they don't use the term parental alienation. They use the term restrictive gatekeeping.
Okay.
But if you take a deeper dive and focus on the behaviors that concern the court and why the court made these decisions, they're the same alienating behaviors that we talk about in other areas.
Just a different name at the top.
Right.
Yeah.
So that's what works for Nebraska. So if you are in Nebraska, you have to use that term and not just go with your land.
And say PA, right?
Right.
Yeah, right.
You don't need to go tilting at the windmills.
That's fair. That's fair. All right. Like I said, I've enjoyed this greatly. We could do this for hours. We don't have that much time today. One last question, and then we'll get out of here. You got something big you're working on right now?
I'm working on my second book.
Fantastic. How do you have time, by the way, just to do that?
No kidding.
Yeah, I ain't gonna lie. That's amazing.
Well, my wife keeps me on the task.
Well, that's fair. That's fair.
Like you and Janice. I mean, she's a lawyer as well.
Yes.
We both were practicing attorneys in India before I came here to go to law school at Michigan. But she's the one who handles the management of the office, my admissions, licenses, pro-acquisition, everything.
Yeah.
But the book is about family violence.
Okay.
It's a broader topic than parental alienation. So it covers intimate partner violence, domestic violence, child abuse, alienation as well, but also focuses on what's not often talked about is coercive control.
Okay.
Emotional abuse, which also includes financial abuse. People with immigration status who come here and who are married to someone and they need that marriage for their green card or citizenship.
Right.
And they're caught in the abusive relationships for that.
Yeah.
So it focuses on those issues as well, abduction of children.
Fantastic.
So it's a bigger topic, and hopefully should be coming up at the end of the year.
End of the year.
Wonderful.
Yeah.
All right. I greatly appreciate it. When it comes out, we can do it again. Is that fair?
Fair.
That's fair.
It'll be a pleasure.
Thank you so much first, Ashish, for coming and doing this. Absolutely great, as always.
Thank you. It's a pleasure.
It's our pleasure. Guys, thank you for hanging out with us today and riding along with us with our talk here with Ashish. This was episode 17. Stay tuned for episode 18. And like I said at the beginning of this, next month's April. April is Parental Alienation Awareness Month, and you'll see more content on parental alienation from us throughout the entire month.
And be sure to like, share, and subscribe so you don't miss any of our content.
Thanks, guys. See y'all next time.